Hello, everyone. Thanks for participating in our presentation today. A big thanks to the New York Grant Company for asking me to be part of their business education series. New York Grant Company does a lot of great work in helping companies that are expanding from outside the US or launching new operations in the US, or even companies that are moving to different states or setting up additional offices to get subsidies and grants and tax benefits in specific areas and cities in the US. So I'm very pleased to have been asked to present. And what New York Grant Company does really is in line with what we do at SMA, which is mostly focusing on what I call outside-in immigration. So helping people with ideas, investment capital, or existing businesses to launch operations here as a platform for whatever dream they have here to do business in the US. So what I like to do is use the metaphor of the bridge for visualizing what the process is like when it comes to US business immigration, especially for launching new companies. So essentially, it's important to understand that in order to build a bridge, you need a foundation. And the foundation of any US visa application is a US entity. Even if you're an entrepreneur that's launching your own business with your own capital, you need a US company to officially sponsor that visa application. So the foundation consists of the establishment of the US entity, funding of that entity, because the visas that we're going to talk about today require an investment, a business model or business plan with 5-year projections to show revenue, costs, and what the job creation will be. And then lastly, physical office space, an administrative part, and a physical space for actual goods. The second concept here in terms of building a bridge is how to maintain that bridge. And that's something that you will continue to do during your visa application process and for future applications, which might be green card applications or bringing in additional foreign nationals to work for your US company. So one way to do that is to maintain majority ownership. In other words, the foreign entity or foreign individuals have to maintain a majority of the ownership of the US company. The second one is the continuing existence of a US entity. You can't sponsor yourself or sponsor someone for a visa and then close the US company. If you do that, essentially that visa status also expires along with the closing of the company. The third one is revenue and job creation. You have to show that you are increasing the generation of revenue, and most importantly, that you are either creating additional jobs over time or at least maintaining a certain level of employment. And then the last issue, which we're going to talk about, is which path or which lane you use to go over that suspension bridge. And that really refers to the kinds of visas that you need in each specific case. And as you'll see, depending on various factors, you may have to mix and match the different visa categories or paths that are used. Let's talk about those preliminary steps. How do you build the foundation? So the first step is to incorporate. I always tell potential clients and entrepreneurs who have decided that they will launch operations in the US that they should incorporate as soon as possible. There are various advantages to that, but essentially that's what lays the foundation. Now, the immigration authorities, especially at the US embassies and consulates, are a little bit antiquated, and they still like to see ownership clearly established through stock certificates, or in the case of LLCs, articles of organization, or membership or member units. Investment is the second part. The company must be funded sufficiently, and we'll talk about how that's defined. The business plan needs to have 5-year projections. Depending on the visa category and where you're applying, the requirements for the length of the business plan and the specific details vary, so it's important to know where you're applying. And lastly, as I mentioned, physical space has to be enough to house or cover the projected first-year staff. Now, I used to be a corporate attorney, and I no longer practice corporate law. I did that in my first 2 years out of law school at a large law firm. So that gave me the requisite knowledge in terms of how to structure the companies. But this is a very individual decision that's tailored really to each specific case. It also depends on what the entities, if there are any, are overseas. And what's important to keep in mind here is that you have to be willing to show the ability and the willingness to pay taxes. And so you don't want to set up structures that are clearly pass-throughs. So LLCs and C corporations are the ones that are typically used. And here in the US, there's something called an S corporation. Those are used really as pass-throughs, and they do not qualify for the visa petition purposes. So either one of those can work, and what you need to do is speak to your corporate counsel to see which one is probably the best for that case. The second question is where to incorporate. So as some of you know who are overseas, Delaware is a very popular place to incorporate. There are other states that also give tax incentives, like Nevada, Wyoming. And then generally, after companies are incorporated there, then they register in other states as what's called a foreign company, or register to do business in the other states where they're going to be doing substantial business, where they're going to be paying sales tax, and most importantly, where their headquarters will be, where they'll actually be physical employees. So the first step is to decide LLC or C Corp. There are pluses and minuses to each one. And then specifically where to incorporate. Generally, my clients incorporate either in Delaware and another state, or directly in the state where they're going to do business. The great thing about immigration law is that it's federal, so we're able to help clients that are setting up their businesses in any state, any of the 50 states. So visa waiver is part of a program called ESTA, and essentially there are 38 countries in the world on the ESTA list, which allows any national who's an adult essentially to travel to the US for business visitor purposes. And that's without requiring a visa, with up to 90 days stay periods per visit. Now there is a limit to that. They are monitoring how much time people spend in the US to make sure that they're not working without authorization. But it's important to understand that if you have a B1 visa, or if you are from an ESTA country, that you will be able to lay the foundations that we just talked about without getting a specific visa. If you're from a visa waiver country, or if you already have the B1, you can do the following that's on your screen here, which allows you essentially to do everything you need to lay the foundation. So consulting with associates, meeting with potential clients, potential collaborators, distributors, companies that you may be contracted by once you've set up your US operations. And then the most important one here, obviously, is negotiating contracts. Essentially anything that you need in terms of documentation, like opening a bank account, incorporating, securing a lease or a premises for physical space, signing contracts for services to be provided by or for the company. Those are all very important in terms of showing a strong case once you submitted it. What is not allowed? Well, employment. And that means anything that can be considered a form of payment. So once the US entity is established, it's very important that funds not be used by the US company to cover one of the individuals who's visiting, who may be a founder, an investor, maybe an employee, manager, or executive of the foreign entity, if there is one. The US entity should not be spending one penny, not even a taxi cab ride or a meal, on that individual while and until that person has an authorization to work, because that can, if that's discovered, that can nullify any pending petition or any future petition. The other one is you can't go from visa waiver to permanent residence. There's no extension or change of status. So you have to be careful that once you apply for the appropriate visa, that's when you go on the payroll and are actually working. You can't change from visa waiver to a visa status. The other thing is about intent. So since they're tracking essentially all of physical presence and all the time that's being spent by people on visa waiver or B1 for the previous 12 months from the date of entry going back, if you've spent the majority of that previous year in the US, they could insinuate or infer that you have the intent to immigrate, and that could nullify future petitions. So do not use US company funds to cover individual costs. Another one is once you've invested the funds and applied for a visa, sometimes we have cases where we have 3 or 4 visa applications pending for the same company. You don't want to move those funds back to the foreign entity until all the visas have been secured, because if there's follow-up from the embassies or from Immigration Service and they ask for updated bank accounts and they see that the funds have been returned, they will not believe that this is a serious commitment, that there's a real risk that's being taken, and those petitions also might be denied. Lastly, if you work for a foreign company, it's always best to say that you're here in the US attending conferences or meetings on behalf of the foreign company, and not saying that you will be working for a US entity.